All right. So when we left off on Tuesday, I think we were talking about defenses to crimes. And so we're going to switch gears for just a sec and go into constitutional safeguards um, that relate to criminal law. Probably the most, well, I wouldn't say the most important one, but one of the most well known and one of the most important ones is our Fourth Amendment protection against unreasonable searches and seizures. So you've all have heard of that in some form or fashion. And our case that I asked you to read is a Fourth Amendment case. And it quotes the Fourth Amendment, which basically just says that we have the right to be secure in our persons and our dwellings and our effects from any warrantless searches or unreasonable searches and seizures of our property by the government. So that one little sentence has spawned a pretty big body of law as it relates to search and seizure. And it's also something that's changed pretty significantly over the years. Your case talks about how when the Fourth Amendment was conceived and enacted, that um, it was more related to, we thought of it um, as more related to trespass like activity, like someone can't come in our home or enter our dwellings or our structures without permission or without a warrant. But now it's grown to be much more broader in scope because we can enter into somebody's privacy without physically entering in. So the Fourth Amendment has changed pretty significantly over time. Um, the basics of what the Fourth Amendment protections are that anywhere where you have a reasonable expectation of privacy, then you are protected from that being searched or having any of your property seized without a warrant. So, what does it take to get a warrant? The law enforcement has to have probable cause in order to secure a warrant. Probable cause in this instance is loosely defined as cause to believe that the search would reveal a specific illegality based on evidence. So, um, for instance, if law enforcement had a confidential informant that said that I was dealing cocaine, that would be probable cause for them to go to a judge and say, hey, we've got an informant that says Tebow's dealing cocaine. Can we get a warrant to search his house? Um, if they had, you got to have some reasonable suspicion. So they couldn't say, hey, that Tebow is a pretty shady character. And, it wouldn't surprise us if he's dealing cocaine. Can we get a warrant to go search his house? You got to have some reason to believe that the search will reveal the evidence that law enforcement thinks is there. There's got to be some tie to that. Now, in practice, how search warrants work are that law enforcement contacts a judge, and it's ex parte, meaning that it's the other side is not there to hear it. It's only ex parte means just one side talking with the judge. So it's only law enforcement. So if they want to get a warrant to search my house, I'm not there in front of the judge to hear what they say. It's very often a phone call, sometimes in the middle of the night. Hey, judge, this is detective whatever, and this is our evidence, and we want to get a warrant to search Mr. Tebow's office at CSU. And the judge would listen to what their probable cause is and either say yes or no. Later on, if they do execute a search and I want to challenge the search, I still get to do that if I feel like that there wasn't probable cause, or if there was something wrong with how it was obtained. I can still challenge that in court. So it's not like law enforcement. They do get to go tell their side of the story to the judge privately to begin with, but it's not like I don't get to challenge that later on. JJ, does your dad sign search warrants? That was going to be the next question. They call in the middle of the night sometimes. It wakes. Yep. And they're telling him, oh, they'll come to your house. Yep. So yeah, they'll get him up in the middle of the night. If they need a search warrant, they need a search warrant. So that's probably one of the things he likes least about his job is being woken up in the middle of the night for search warrants. That doesn't bother him. Well, if we're lucky enough to get him to come talk to us, that will be I'd be interested in hearing about. Does he? Is he really busy? We may not bother him this semester then, but I would love to hear about like what goes through his mind when they're telling him what are some ones maybe he's turned down, something like that. So anyway, that go ahead. You, I mean, I'm not sure I'm not sure exactly how that works. I don't think you get to just go to the next judge in line. I don't think that is. But now, does that not happen? I mean, it might happen, but I think if one judge tells you no, you're shot on that. You've got to when you come back, you've got to have something new. Um, is how I believe that would work. I think that, and I'd love to ask Judge Graham this, but I mean, I feel like most of the time the judges are going to err on the side of caution and just say, yeah, go search. And then if there's a problem with the search or if they didn't have probable cause, it can just be challenged later. I mean, I don't mean to suggest that they just rubber stamp it, but if I'm only hearing one side, there's not many law enforcement officers that are going to wake a judge up in the middle of the night and be like, "Listen, this is kind of shaky. I mean, I don't, this is not really good probable cause, but I thought I'd run it by you anyway. I mean, that would really tick me off if they woke me up to tell me that they had a flimsy case. So, but I also think that I think law enforcement personnel have to be very careful with their credibility before a judge because if you bring a bullshit probable cause before a judge, the next time you come, that judge is going to be very wary of giving you a search warrant. If you keep getting them overturned, judges do not like. Well, nobody likes to have it point out that you made a mistake or that you were wrong or something. But judges in particular don't like that. So, um, all right. So one other thing to know about the Fourth Amendment protections are that remember that it only applies where a citizen has a reasonable expectation of privacy. So things that are, um, if I have uh, my backpack full of cocaine and I've got my backpack open and it's sitting here on the table open and a law enforcement officer were to happen to stroll through, they could arrest me for that. It's not an illegal search and seizure because I don't have a reasonable expectation of privacy in something that I'm displaying to the public. If it's locked, I mean, if it's zipped up in my backpack and my backpack is down here under the desk, I have a reasonable expectation of privacy in that, but not if I show it openly. In the case that you read, the Carpenter case, you'll see that there's sometimes when we voluntarily give information about ourselves out, we lose an expectation of privacy on that. Like when we make outgoing phone calls, for example. All right, so let's move along to Fifth Amendment protections. Due process is an idea that I always thought was a little bit hard to wrap my head around. Because yes, the Fifth Amendment guarantees us due process, but that's never really defined anywhere. There's not like a specific due process law. Due process just means, in an overall scope, that the law has to be carried out in a fair and orderly way. So if something happens to me along the way, like I didn't get read my Miranda rights, or the government didn't turn over some discovery, or my trial got pushed to an unreasonable time frame, that might be violations of my right to due process, meaning just that that the whole administration of justice, the whole me going through the system, all that has to be done in a fair way. Um, it also does include some specific things like the right to cross-examine witnesses, the right to object to charges against you, the right to present a defense. Those are all due process things. So, like I said, due process is not necessarily like one specific statute. It's an overarching idea that encompasses a whole lot of protections that go to fairness, basically, for a defendant. Double jeopardy, we talked about that before, I think. Once a defendant has been acquitted, then that person cannot be tried again in the same court for the same crime. A federal court, if a person were acquitted, found not guilty in a state court, if there's a corresponding federal crime, then they might be tried in a federal court for that. It's just that you can't be tried in the same court for the same crime. Self-incrimination, the Fifth Amendment protects us from having to testify under oath about anything that might incriminate us with criminal liability. We can't plead the Fifth for civil reasons. Just because I think something might embarrass me or I don't want to answer it, that's not the Fifth Amendment. Like I've had, if I've taken a deposition of someone in a divorce case and the spouse is accused of cheating, that spouse can't say, well, I plead the Fifth. It's not a crime. So they're not incriminating themselves that way. And I've had some try to do that. But anyway. Sixth and Eighth Amendments. Sixth Amendment is the right to a speedy trial, the right to a trial by jury, the right to have a lawyer. So in a criminal case, if you can't afford a lawyer, you'll get one appointed. That's not true in a criminal case. There are a lot of folks who think that they're required to get lawyers in civil matters, and that is not the case. But you will get somebody from the public defender's office if you are charged with a crime and you can't afford or can't, for whatever reason, hire your own attorney. The Eighth Amendment, that prohibits excessive bail and also prohibits cruel and unusual punishment. And so that applies to and extends to like prisoners' rights and what they're how they're provided for when they're in jail. I think we touched on the exclusionary rule on Tuesday, but just briefly again, if law enforcement obtains evidence in a way that violates a law or violates due process, then that evidence cannot be used against the defendant. It's not admissible in trial. And if there's something that law enforcement did that violates due process, any evidence that they get as a result of that is excluded. So that's called fruit of the poisonous tree. So it doesn't matter if they search my house and let's say that they didn't have a warrant, they could find evidence that I have committed mass murder, and they cannot use that against me because the warrant was not legit. So anything that they find is excluded. The Miranda rule, y'all are familiar with Miranda, I think. You have the right to remain silent. Anything you say can and will be used against you, etc. You have the right to consult an attorney. All those are the Miranda rule. If anyone is not read their rights and then evidence is collected after that in terms of like a confession or anything that the defendant says while they're in custody, but before they have been read their rights, then that is not admissible in court against them. The criminal process is, and there's not much to that. It's basically what you would think. A person is arrested, then they're formally charged with a crime. Many times, in a lot of jurisdictions, the district attorney's office or whoever prosecutes the crimes will have to take the evidence before a grand jury. And the grand jury's job is not to decide if the person did it. It's just to decide that if there's enough evidence to proceed to go on to trial. If the grand jury decides that there's not, then the charges are dropped and the prosecution doesn't proceed any further with that. But if the grand jury says there is enough to keep going, the grand jury's done. They don't keep going in the case. It's a totally different pool of jurors that would serve as the jury in the actual trial. And we talked about that, I think, a little bit earlier this semester when we were talking about all the Trump indictments. It just means that in a lot of those cases, a grand jury has heard some of the evidence that the government has, and they've decided that there's at least enough there for the process to keep going. And then we talked in civil law about how the discovery process kind of lasts a long time, and that's a big part of a civil legal proceeding. It is in criminal law too, because you certainly do want to know what the evidence is that the government has against you, but it's not as hard to get in a civil trial. In a civil trial, you saw where if I want to get evidence from the other side, I have to ask them, and I can't just say, give me everything you have. I've got to ask them specific questions and make specific requests. In a criminal trial, the government's got to give you what they have. That's by law. That's automatically. You don't have to ask for certain things and make sure you ask for the right thing. They got to give you what they got. And they have to give you what they have in a pretty short period of time up front. So whereas a civil case could take a long time to go to trial, it's possible for a criminal case to move through the system pretty fast. Now, that doesn't mean that they do. There are people sitting in jail right now that were arrested a year ago and still haven't been indicted. And that's problematic for a lot of reasons, for the reasons that are really beyond the scope of our discussion today. But the defendant always has a constitutional right to demand a speedy trial, and that can certainly speed things up as well. But I think you got to be indicted before you can get a speedy trial. I'm not totally sure about that. And then the trial works very much the same way that the litigation process works in civil law when we talked about how that trial works with opening statements and presenting witnesses. Maybe one of the bigger differences is that a lot of times in a criminal trial, you won't have the defense put up any evidence. They'll be satisfied for the government to try to prove their case, and they'll be satisfied to try to just poke holes in it enough that they can just argue to the jury in closing that, hey, the government they didn't prove that my client was guilty beyond a reasonable doubt, so therefore they should be acquitted. A defendant certainly can put on all the witnesses they want to, and if they've got good witnesses, they would. But I would say more often than not, I would estimate that the defendants probably don't testify themselves. You still could have other witnesses, but it's less common for a defendant to actually take the stand. Especially in cases, we were talking last Tuesday about cases where, I think we were talking a little bit after class about this, but where everybody kind of knows the defendant did it, or the evidence is really, really damning, then you're a lot less likely to have the defendant on the stand because there's just not much they can say. All right, your outline talks about cybercrime, and I mean, here's how I feel about this discussion. Cybercrime is a huge problem. But I don't think that, like, this outline that I'm using is based off a textbook that's several years old. I mean, cybercrime is kind of like cutting edge. The law is always behind, I feel like, in things like cybercrime. I mean, the criminals are just way out ahead of how fast we can legislate and how fast we can regulate that kind of stuff. And also, cybercrime is pretty self-explanatory. I mean, I was going through it last night again, and I mean, we all know what online fraud is: cyber theft, phishing, hacking, cyber terrorism, those kind of things. So I'm not testing you on the cybercrime stuff, but I have included it just because it's probably an area where we should be talking a lot about. It's just I'm not really sure. I just don't have great materials on it for the reasons that I have kind of told you, and it's just sort of self-explanatory. I mean, people are using the internet to commit a crap load of crimes. Um, that's my scientific, scholarly assessment of cybercrime. Any questions on that? Yes, sir.
So, for instance, let's say someone, their account is right out of, say, $50,000, and they report this fraud, but they did themselves, but can't prove fraud.
They did it to themselves, but they reported it
Reported this fraud.
to keep from having to pay or something. I mean, that would be fraud.
How would the law work around that? Because I've seen a lot of instances.
They've gotten away with it because nobody caught them, or they got away with it because they were prosecuted and found not guilty. Right. That's the big issue with cybercrime. Like I think I was complaining the other day to y'all or somebody about, the 200 scam emails I get every day, which is it's fraud, it's criminal. But the way that they hide their addresses and location, I mean, all that's way over my head. It's hard to catch them. I was telling y'all the story about the guy that I served as conservator for. Did I tell you all this story? That was sending all the money to New York and all that. And I got the GBI involved, and but they couldn't. I mean, they looked into it, but there was not much they could do, and so um, that was very demoralizing to me to be like. I think it's a lack of personnel, and I think that it's really hard to do. So I mean, like I think if they put their crack FBI cyber crime unit on my guy's case, they might could have found that person, but that happens hundreds of times a day, and they're just not going to devote their resources to that. That's what I think. I think the fraud part would be easy. I said that the law lags behind, and it does, but I don't think it's that hard to prove that that's fraudulent activity. I mean, I think there is sufficient law to probably cover it. It's just what lags behind is the ability, like the criminals are out ahead of the law and law enforcement, is what I think. But I'd be interested in hearing. I'd love to have somebody who's an expert on that talk about it. I wonder if the GBI and GBI has an office in Columbus. I wonder if they have anybody down here on cybercrime. Might try to look at that for next time. All right, so let's look at the Carpenter case that I assigned y'all to read. Who can tell me what happened? What was the original underlying crime that Mr. Carpenter committed? Y'all remember that? He was involved in some robberies, right? Was it bank robberies or store robberies or? But it was a series of robberies or something. He was. All right, and how did they catch him? How did the law enforcement catch him? Through his phone. And what about his phone led law enforcement to him? All right, and how did law enforcement get his location? The cell company, right? And did law enforcement get a warrant for that information? They did not, right? That's the rub of this case is that they there is something called the Stored Communications Act, and apparently law enforcement can apply for an order to compel production of some communications without a warrant. Similar to going to a judge, I would suppose, to get a search warrant. This is just I guess, a variation of that. I don't know if you're getting an order under that law, if you have to go to court and present evidence, or if you call up a judge, kind of like you do for a regular search warrant. But however they did it, law enforcement got the location information for Mr. Carpenter's cell phone from his cell phone company without a warrant, and they were able to map his whereabouts based on how your phone communicates with the cell tower. And they determined that he was within proximity to all of the robberies at the time that the robberies occurred. And so based on that, he was arrested, and then he was convicted, I believe, at the trial court. So at trial, did Mr. Carpenter object to the cell phone location evidence? Y'all remember that? He appealed, and what did he appeal then? Right. So remember, when you appeal, you're not appealing issues of fact, you're appealing issues of law. So he was saying, at my trial, I asked the court to exclude the cell phone location evidence because I believe that that was obtained illegally, that that was a violation of my Fourth Amendment right. The government didn't have a warrant to get that, and I believe that's unconstitutional. And the trial court admitted the evidence and said basically it was constitutional. So that's what he was appealing. He was not saying, okay, appeals court, I didn't do it. He was saying, appeals court, the judge at the trial court level made a mistake in allowing that evidence in. And so we went to the appeals court, and then we went all the way up to the Supreme Court, who decided this case back in 2018. So before we get into what the Supreme Court decided in Carpenter, let's look at some of the earlier Supreme Court cases that were precedent that the Supreme Court had to navigate in deciding Carpenter. And one of them was United States versus Miller. And that addressed police access to business records held by third parties, which I believe was banking records. So in that case that served as precedent, did the court allow law enforcement to get banking records without a warrant? They did. Susie says yes, she's right. Well, why is that? Why was that? Why did they not need a warrant to get that? The financial records that actually belong to the bank, not to tell me I got a low battery. That belong to the bank and not the person. Good. So that's one case that we're going to have to deal with in deciding if the Carpenter case is more like these or unlike these. The other one was Smith versus Maryland. That was police access to non-content phone records. So not recordings of what you said or your text messages. It was like just who you called. So what did the court say in Smith versus Maryland? Did law enforcement need a warrant to get the non-content phone records? They did not. Why didn't they need a warrant for that? What is it about outgoing call records that's similar to the bank case? All right. And when you make a call, Jesse, when you voluntarily make a call on your phone, what are you doing with that information? I mean, you're putting it out there. You're putting it into the public. You're giving it to the cell phone company, right? That's something that you're doing voluntarily. That you're forfeiting your privacy right in that. Good. And so those cases, what the court used in those cases was this idea of this third-party doctrine, they call it. And that's the legal principle that when an individual voluntarily gives up information to a third party, then they lose their privacy interest in that. So that's exactly right, Des, what you said. They forfeited that. All right, so third-party doctrine is going to play a role in the Carpenter case because it does involve records from a cell phone company, which are a third party, right? So we've got to get around third-party doctrine somehow in this case. The other case that the court talks about as precedent is this U.S. versus Jones. That's where police put a GPS tracking device on a car, and the court found that law enforcement did need a warrant to do that. What is it about putting what is it about a GPS tracking device that's different from outgoing call records or bank records? Your expectation of privacy? In what way, Susie? Very good. You're not I didn't give somebody permission to put GPS on my car, right? And the GPS on my car is tracking me. I'm not voluntarily putting that information out anywhere. You're following me with that. And so the court said, yeah, a citizen does have an expectation of privacy in that. So those are the cases that were the sort of main precedent that the court had to sort through when they were deciding this case. Your article talks a little bit about the technical background. I think everybody understands how cell phones work. If you send a text or a call, then your phone's communicating with a cell phone tower. That's very much like making outgoing phone calls, right? But your phone also communicates with towers involuntarily. And that is much more like the GPS case and much different than the bank records or the outgoing calls case. That's sort of the way that the court was viewing the precedent here. So, skipping to the court's opinion. What was the conclusion then? What did this court conclude about whether or not law enforcement needed a warrant to get Carpenter's location information? Did they need one or not? They did, that's right. And back up here. So the court talked a little bit about the history of the Fourth Amendment, and I mentioned that already when we were talking about it as part of the lecture, that, you know, when it first began, we thought of it more as things like physically entering our house, and now it is expanded. The courts like to use the phrase that the modern understanding of the Fourth Amendment protects people, not places. They also cite some how technology has really enhanced surveillance and the ability of the government to search without physically entering. They mentioned this Kelo versus United States case. In that case, there was a dude who was growing marijuana in his basement, and the police suspected it, but they didn't have probable cause to get a warrant, or they didn't bother to get a warrant. But they were using thermal imaging on his house. So they were detecting an abnormal amount of heat coming from the house, and they suspected that that was because of his grow lamps. Basically, it was a grow house. And they arrested him based on that. And he raised the defense of, you searched my house without a warrant. And they're like, well, we didn't search your house. And we're like, yeah, but you did, because you basically penetrated the walls of my home, you know, without permission with technology. And the court found that that the government should have gotten a warrant in order to do the thermal imaging on Kelo's house. So that evidence was excluded. So that was just sort of explaining ways that the Fourth Amendment has evolved. The court then talks about how, you know, the cell phone location information straddles or lives somewhere in a gray area between the third party doctrine and these cases like where GPS was found to be an invasion of privacy. Because yes, your cell phone is giving out some information because you cause it to, but it's also doing it involuntarily. And so they said it just doesn't fit very neatly into those third party doctrine cases. What is it about? What did the court say about how we use our phones today that really make this case different from the third party doctrine cases? Good, very good. I was hoping you could catch that, and it really is. How do y'all get panicked when you can't find your phone? I do too, and I hate that feeling so much. But it really is kind of a part of our anatomy. And he said that our phones show everywhere we go, so it can show our work, our personal locations, what we're doing, and that level of tracking or surveillance does invade an expectation of privacy, such that law enforcement would need a warrant to get that information. Now, here's a question I have for you. The court says in this case that the government in this case got 7 days of records. And the court is saying, we're not saying that law enforcement would need a warrant to get the location information no matter how long the duration was. So what do y'all think about, we've got a court that says 7 days needs a warrant. So anything more than 7 days, we've got precedent that's going to support needing a warrant for that. But what about less than 7 days? What do y'all think about that?
It's kind of vague because it's not anything less than 7 isn't necessarily a schedule of movement. 7 days.
Mm-hmm.
Normally throughout the week, so anything less than a week have something.
Right. So it's sort of the idea of a snapshot, which might not be an invasion of privacy in the way that the court describes how our cell phones work with us. But the more information you get, the more fuller picture you would have. Is that what I think you're trying to say? So what about 5 days? Judge Des, what do you say?
5 days.
It's not long enough? So you don't need a warrant? But you do for 7? All right, and if you're writing your opinion, and that you've already given us some of your reason, but any other reason that you would give to why you need a warrant for 7 but not for 5?
Well, actually, no, because 5 days could be an average work week.
Okay.
To show where you go to work.
Yeah, because remember, if you're the judge, you're going to have to explain why your case is different from Carpenter. You've already got it, the court saying 7 days needs a warrant. So if you're saying anything less doesn't, let's say 3 days, what is your decision on 3 days?
3 days.
3 days isn't strong enough? What do y'all think? Let me ask it this way. You're not Judge Des anymore, you're Citizen Des. Do you want law enforcement to call your cell phone company and get 3 days worth of your records without a warrant?
Definitely not.
Now, your police chief does. Do you want to be able to get those records without a warrant? Of course you do. What do y'all think about 3 days? What do you think, Caleb? Yeah. I don't like 3 days. I think you gotta have a warrant on that. I mean, I almost think like if they were investigating me for a series of robberies that took place on a Sunday afternoon, I don't want them having 5 hours of my cell phone location. I really don't want them having a snapshot of it because it might put me right there in there. But
From the way that I see it, your GPS location is something that you are inherently aware of.
mm-hmm.
So it's not like you're giving out.
Right.
But with cell phone calls, GPS location is like, it's always happening. You can't really help that.
Well, that's a good point. I suppose that the government, if they want to know where I was on a Sunday afternoon without a warrant, they still could get my outgoing call information from the cell phone company. But I don't know if that's not going to tell my location, though. I mean, they gotta.
They don't do anything relevant to your investigation for 3 days. Maybe
Yeah. I think. I mean, my opinion is that I think that if the Supreme Court had a 3-day case, they would say get a warrant. It's the hours that I'm not sure on, but based on their rationale that your cell phone is a part of your body, I mean, it goes wherever you go. I sort of think that maybe you'd have to have a warrant, um, but it's not clear from this case. The court did not rule that all CSLI requests need warrants. All right, let me look down my list of questions and see if we covered everything I want to cover on Carpenter. Anybody disagree with the court's ruling in Carpenter? Think that law enforcement should be able to get 7 days of location without a warrant? It depends on your perspective, right? Are you the defendant, or you know?
there's a separation between feelings and the law holding up the law.
Yeah.
So
Well, and there's we've talked about the Fourth Amendment very generally today. There are all kind of exceptions to the Fourth Amendment. Somebody, officer pulls you over and you've got something in plain sight, that's an exception. If I have a huge brick of cocaine in the passenger seat of my car when I get pulled over for speeding, they don't need a warrant for that. It is in plain sight. There are some exceptions that have to do with emergencies. Um, so there's a huge body of law with respect to how the Fourth Amendment works. All right, let's review some. Oh, pull up the Georgia criminal statutes. Let's look at those for a second in your content module. And if you haven't read those, take a quick second to read through those. Didn't realize that, huh? Anybody still reading? Y'all good? All right, let's look at the battery statute first then. Remember we talked about a couple things of review then. Most crimes are defined by a statute. So the statute is going to lay out the definition of the crime and what has to be proven in order for that person to be convicted of that crime. So remember that. And then we also talked about how the statute is going to say what kind of mental state is required in order to convict somebody under that statute. That's the mens rea. So what is the mens rea under the battery statute? What does the statute say the state of mind needs to be? What is the criminal state of mind to be guilty of battery? In part A. Intentional. Very good. Yep, in order to convict me of battery, the state is going to have to prove that I intentionally did what they have charged me with doing. Good. Substantial physical harm has to be caused. Who's going to decide at trial whether or not the harm was substantial? It doesn't say this in the statute, but this is sort of a review. Well, yeah, that will be the evidence of it. Good. Who will make the ultimate decision about whether or not the harm was substantial? The judge or the jury? Good. Depending on if there's a jury trial. All right. Does this statute require that the harm be substantial and visible, or one or the other? One or the other. Good. That's right. Look at the robbery statute then. What's the mens rea under the robbery statute? Intent. Good. You got to have intent. So if anything less than that, they would have to look at a different crime to charge the person with. What's an example of make up an example of something that would qualify as robbery under this, as defined by this statute? And what else? Is it just holding somebody by gunpoint? All right. So give me an example of that. All right, good. Now notice, I want you to appreciate this. If I stole Susie's phone, but she didn't see me steal it, it doesn't mean that I haven't committed a crime. I just haven't committed the crime of robbery as defined by Georgia statute. They couldn't charge me with that because I didn't do it. Well, I guess I could have done it by sudden snatching. Let's say I didn't do it by sudden snatching. I didn't do it by force, intimidation, or snatching. There is going to be a statute that what I did fits under. Is probably just larceny, but it's not fitting under this particular statute. What if, let's say that I am robbed by Johnny. Wait a minute. Let me make sure I do this right. Let me change this. Eric is robbed by Johnny on the day before his 65th birthday. Eric is then robbed by Jack the next day on his 65th birthday. If Jack and Johnny are each convicted of robbery as defined here, what's the minimum amount of time that each will spend in prison? What will Johnny's sentence be on a minimum? At least 1 year? What would Jack's minimum sentence be? Right, and that's because why? Right. Very good. Exact same act, but their victim had a different status. That's a great question. Do you think that we should punish people for robbing elderly people? That would be the first question. Yeah. Right. But where do you want to increase the punishment for robbing old people? At what age do you think we should increase that? 50? Thank you, Des. Thank you so much. 60? So 65, y'all feel like we're not doing enough to protect the 60 to 65-year-old people. All right. Interesting. Yeah, yeah. Well, America's gotten soft, right? So that age should be going down, maybe. I don't know. JJ's right. There's some 65-year-olds who could kick some ass. Apparently Eric couldn't. He got robbed 2 days in a row. Terrible. He even has a big target on his back. All right, look at the criminal trespass statute. What's the mens rea under the criminal trespass statute? It's also intent. That's right. All three of these are intentional. What is an example of, give me a fact pattern that would qualify as criminal trespass here?
If I went on to nice land, cut the tree down, oak tree.
Okay. You entered upon the land. Yep. For an unlawful purpose, right? Okay. There you go. Your unlawful purpose was cutting down his tree. All right, good.
If you gave someone permission to come onto your property, so they're not trespassing when they come on, but then they damage something, intentionally, they could still be charged.
Well, let's see. Yes, because I don't see anywhere in the statute where it mentions permission. So it just says enters upon the land or premises of another person. So I could run a Walmart. You could come in my Walmart with permission, but then do some criminal trespass while you're there, I suppose. The jury. I think that if you, but I think if you wanted to use the defense that they've charged you with a crime and your thing wasn't $500, I think you would have some preliminary hearings to determine whether or not the damage was $500 or not. I don't think you'd wait to trial on that. I think I'd raise my hand on that pretty early and say, Judge, we need to have a hearing just on the amount of damage. I suppose you. It would mean that they would have to charge you. You're not guilty of this crime, as defined. You're not guilty of criminal trespass as defined by Georgia law. Now that doesn't mean that there aren't other crimes that you might meet, and I imagine you would.
Just $500
or less. Oh, okay.
So I'm assuming it's above that.
Gotcha. Okay, my bad. That's right. Anything over 500, there's another crime that, and I don't know what it is, but there's something else you qualify for. Any questions about, after reading these statutes, anything jump out at you or anything you curious about? That's a good question about the age limit. How did we decide that? Yeah, yeah. Most of the immunity that any government official would enjoy would have to do with their official duties. So, yeah, anything they do, they're just a private citizen then.
65 days you can draw.
Social Security. So when you turn 67, you can draw full Social Security. But at 62, you can draw a reduced amount. Like, I think it's if you start at 62, you'll get 30% less than you would have gotten if you waited till 67. It doesn't go up when you get 67. That's just you start getting at 62 what you're going to get. And then I think every year after 62, it increases by 8% or something like so. If I wait till 63, then I'll get 22% less. Something like that. I'm about to sneeze. Excuse me. Thank you. All right, let me run some criminal scenarios by you. Based on the specific crimes we talked about in class Tuesday. Some vandals busted the lock to gain entrance to the Little League concession stand. What could we charge them with? You laugh, but when I was in Little League, that happened almost every night. Get a call to go down to the damn concession stand and meet the police officer because somebody tried to break in the concession stand where there is no cash. popsicles and old nacho cheese. Yeah. I still have nightmares about working the concession stand and then the nacho cheese. All right. What did y'all say it was? What crime did we decide? Trespassing? Yeah, it could be trespassing, but that's not one that we talked about on Tuesday. Trespassing could also be a tort, remember? So what crime did we talk about? Look at your outline. Say it again. It is a property crime. So there's a specific one, Yulia. You're right on the right track. Burglary. Good. Right. While Johnny was at his son's Little League baseball game, he inadvertently overheard Ned, the CEO of ABC Corp, talking on his cell phone. Ned was telling one of his vice presidents that the company had received preliminary approval from regulators for the first COVID vaccine and that the official announcement would likely be made in a week or two. Johnny immediately calls his stockbroker and buys 50 shares of ABC Corp. Insider trading, very good. Paul works in an auto dealership. He takes a payment from the customer of another salesman and puts it in his desk for the night so that salesman will be blamed for the missing payment. After that salesman loses his job, Paul turns in the money, claiming he never intended to keep it. He was just holding it for a couple days and he forgot to turn it in. Can we charge him with anything? Embezzlement, good. Thad pulls a gun on Ursula and puts it 2 inches from her face. She faints and busts her skull on the pavement. This is just like one of the torts we talked about. I don't know that your outline. It'd be assault, yeah. I don't know. Could even be aggravated assault because of why? Because he's using the gun. I mean, yeah, that's not in your outline, but yes, when you use a firearm or something like that, it can increase the severity of the crime. All right, Vince is 48. He is arrested for a public intoxication incident that happened when he was in college 30 years ago. What defense might Vince use? Statute of limitations, good. William breaks into a store to put out a fire. He's arrested for burglary. What defense might he use? Good Samaritan. That was tort law. And that was when you rescue somebody and you're not liable for doing it wrong. For necessity. Good, Yulia. Excellent. Xander operates a drug ring. He also has a dry cleaning business. He deposits his drug profits into his dry cleaning account. Good. Bill, a visiting businessman from Russia, met with a state regulator and offered money in exchange for a state contract. When he got arrested, he told the authorities that he did not know that his actions were illegal in the United States because it is common in his home country. What crime might he have committed? Bribery. Is it a defense? Is ignorance of the law a defense for him? Probably not. Very good. All right. Y'all have any questions about anything we've talked about in criminal law? We'll have a quiz. It'll be a lot shorter than Unit 4 because it's just 1 week's worth of stuff. But it will cover carpenter. It'll cover those criminal statutes. It'll cover the lecture. And you have a discussion question for this week. And that's all. And then next week, we're going to start contract law, which is a 2-week unit. There's a lot to talk about in contracts. So we'll be ready for that next week. But if nobody has anything else, we'll see y'all later.